SJC-10448, Springtown, Massachusetts.
Good morning, Mr. Rosenfeld.
Good morning, Your Honor. The single issue before this court is what's the appropriate level of discipline that should be imposed upon the respondent who pled guilty in federal court to one count of one indictment alleging he willfully endeavored to obstruct justice in a case involving the voting rights and redistricting in 2001.
You're asking for a term suspension, am I right?
What's that, Your Honor?
You are asking for a term suspension, am I right?
That's correct, Your Honor.
Do you have any specific years?
2 years, Your Honor.
2 years is what you're...
Yes.
And if we were to agree with you, then he would have served the time already, isn't that right? I mean, this is, because he would be up, it's long since up.
It'll be 3 years in January.
Okay.
The hearing panel, consisting of 3 board members, held a 2-day hearing. They made findings to support their recommendation of a 2-year suspension. The findings were, and I'm going to summarize, obviously, the lack of evil motive underlying the respondent's testimony, the lack of racial animus in his intent in presenting the testimony he did to the committee, the aberrant nature of the offense, and his distinguished career in public service.
I understand all that, but one thing is troubling me. The brief from Bar Counsel states that Mr. Finneran made the same statement at a deposition 8 months earlier. Is that correct?
No, Your Honor, it's not correct.
That's not correct.
No. I think what happened at the deposition, Your Honor, and I think the board misconstrued this. The board looked at the testimony that was on, I believe it's Exhibit 11 in the record appendix, pages 82 to 84 in his prior deposition. What they didn't take into account when they were judging his answers at that prior deposition was the fact that counsel was instructing him about how to answer the questions and was telling him, claiming regularly the legislative privilege and telling him he could only testify as to any kind of statements or discussions that were made in public after the redistricting plan was submitted to and put on the floor of the House.
Wait, how do we know what counsel was telling him?
Well, you can read some of it because counsel was giving him instructions about don't answer this, about anything to do. And if you read all of the testimony from the deposition that's in the selected pieces in the record appendix, you'll see that counsel constantly was advising him only answer with regard to what was public, not anything that happened before that, because it's covered by legislative privilege. Now, that was never contested at the deposition. When it got to the actual case before the First Circuit, the judges
You're talking
disallowed
about the First Circuit or the three-judge panel?
a 3-judge panel. Yes.
Yeah.
They disallowed the legislative privilege, and therefore it was pretty clear as far as what kind of a framework the respondent was going to answer in. But the framework in which he was put at the deposition changes, I think, the analysis of what the testimony was at the deposition.
Mr. Rosenfeld, let me just see if I can understand this. As I read there was no claim, I don't think, that the United States government was proceeding on the basis of testimony given at the deposition, correct?
That's correct. He only pled to what happened on November 14th, which was before the 3-judge panel.
The deposition testimony is in evidence before the hearing committee at the board?
Yes, it was. Some of it was.
And what was the basis of the introduction? And who introduced that evidence, and what was the basis of the introduction?
The basis was that two bases, I think. One was that his testimony before the 3-judge panel was an aberration.
Okay.
And the second was that the possibility of impeaching his testimony at the hearing committee hearing, where he testified about what he testified in court, and comparing that to what he had testified at the deposition.
Mr. Rosenfeld, I'm new to this area of law since some of the SJC and the BBO which handles it, but I can't find any case from my review where there was a felony conviction for perjury or obstruction of justice and the sanction was not disbarment or indefinite suspension. Are you aware of any cases that we have ever done
Well,
in
I don't
which there's
think
been a
that-
felony conviction for perjury or for obstruction and we have given anything less than disbarment?
First of all, Your Honor, there's no, perjury is not involved here.
I know, but perjury or obstruction of justice, but well, although he
We're
did
talking
admit
about-
although he did tell Judge Stearns that he had lied.
We're talking about the endeavor to obstruct justice.
Right, but
number one.
I read his plea
And there's
hearing,
no-
and he did agree that he lied, did he not, before Judge Stearns?
Right. I don't think there's any similar case, actually. There are, and Bar Counsel is citing two decisions involving convictions, and this is a conviction case. There's no question about it. We analogize it to some extent to cases that weren't conviction where people testified falsely, but this is a conviction case. But under conviction cases, under Conchemi and Nickerson both, this court has held that if there's a conviction, the usual or the presumptive discipline is going to be disbarment or indefinite suspension. The court has varied from that, however, on a number of occasions.
Right, I'm aware of that. But my question to you is, are you aware of any case involving a felony conviction for perjury or obstruction of justice in which our sanction has been anything less than...
I can't cite you to a case to do that, Your Honor, at this point in time. But I can point out that there are several cases before that the court has decided involving convictions and involving serious conduct where they haven't disbarred or indefinitely suspended a lawyer. And I think those are more appropriate. If you...
Now, why is that here? I mean, this was obstruction of justice during the course of a civil trial?
I think if you look at the court frequently looks at the underlying factors in the case. If you look at this particular case, you'll see that it was a different obstruction of justice than any other, and this was articulated very well by the Assistant United States Attorney, Mr. McNeil. He said that it didn't involve, if I can just quote him.
It's in your brief a couple of times.
What's that?
It's in your brief a couple of
It's
times.
in the
so
brief
we've
a
all
couple
read
of
it.
times,
Yeah.
correct. And what he said was it was unlike because he was not trying to, it was not done for evil motive. It was not done to try to protect someone who was a fugitive. It was not done to gain for personal gain. None of those purposes were there that are usually there in an obstruction of justice case that was brought. And he differentiated it from other obstruction of justice cases, and I would suggest to you that it is different than other obstruction of justice cases. It's not a perjury case, and that it ought to be treated as different from regular obstruction of justice
So what
cases.
would the rule be going forward if we agree with you that a person who has an honorable reputation can engage in a one-time aberration and not be disbarred? Is that the rule?
I wouldn't say that's the rule. I'd say that each case, as this court knows and is set out in Finneran, is decided individually. And I think you have to look at this particular case to make that decision. You have to look at, number one, what were the underlying factors in the guilty plea, and what he did that where he ended up with a felony conviction. You have to look at other factors such as, for example, the fact that he did this not as a lawyer, practicing lawyer, representing someone in court, but he did it representing anyone. He did it as a witness in a hearing. Third,
But he did it representing all the citizens of the Commonwealth. He held a position in which he represented well, at least a large portion of the citizens, and perhaps all, given his
And I'm not denying that. I think that
You're not relying, are you, that this is a sort of private, private in a personal capacity? I mean, in other words, would you suggest that we should not take into account at all the fact that he was testifying because he was Speaker, and this was actions taken as Speaker that were at issue in the case?
Well, he was testifying as Speaker, but that differs from actually being a lawyer representing a client.
No, I understand it's different from that, but there sometimes there's a reference, I think in your brief and other places, to, you're doing something that is a sort of private action, private conduct that's at issue.
Right. No, this was in public, and he was certainly testifying as Speaker of the House. There's no question about that.
Mr. Rosenfeld, would I be correct in sort of stripped of everything else? The essence of the argument is there should be, to coin a phrase, a downward departure from a presumptive discipline sanction, in this case, for the same reasons that there was a downward departure from the federal sentencing guidelines, in essence.
Right. And what you do is you look at the different factors, and I would suggest that what the board did was it took the factors considered by the hearing committee and rejected them one by one. The board...
I understand that, but there are a number of other claims here, because this is a bar discipline case, that has to do with public service, and that this is a...
Right. The public service part, the court has previously held that public service can be a factor in the determination of the sanction in Orfanello, Infinity, in both those cases. Second, the board compared the fact that the respondent was well known to what the court held in the Bailey case. In Bailey, what we were talking about was something completely different. Bailey was, as everybody knows, a well-known criminal practitioner who was convicted of converting his client's funds client property that he was holding on behalf of the client. That's not analogous in any way to what the respondent did in this particular case. So I think that what the board did in that situation is not appropriate. I think that you have to look at the fact that the respondent and the hearing committee gave credit to his public service because it was extraordinary public service, as was testified to by some of his witnesses, Mark Robinson, Lenny Lewin, both testified as to his extraordinary public service. And the court has given credit to that. The other thing I think that's been misconstrued here is there were accusations against the respondent by both the plaintiffs in the case, and Bar Counsel has followed up on that the respondent was racially insensitive, that he was racially biased. That was the whole root of the redistricting case that was brought. And there were findings, not only by the hearing committee, but the assistant U.S. attorney presented to the court, that not only was there no racial bias or no racial insensitivity on the part of the respondent, but that he was proud of the fact that he represented a majority-minority district, which is how they classified it. And the fact that he'd been elected and reelected to that over a long period of time, over 20 years. And and I think the hearing committee also pointed out that led to his anger, resentment, agitation that ultimately led to what he ended up pleading guilty to. Does that make it okay? No, it doesn't. But it's a factor to be taken into consideration in terms of how to judge this. I think the other thing that I want to point out is the board's finding that, or conclusion, I guess it would be, that anything less than disbarment is going to cause harm to the public perception of the bar. I think the board's relying too greatly on speculation and is giving too much weight the character assassination that some media people who claim to represent public opinion. They don't. In this case, public opinion probably, the board would have been better served if it had looked at the testimony of Wayne Budd, Mark Robinson, Lenny Lewin, Tom Drexler, in terms of lawyers and in terms of Rodney Bender, all of whom testified about public opinion. And in that instance, I think that the harm is not what the board suggested when it will not be what, there won't be outrage if the court gives the respondent a term suspension.
Thank you, Mr. Rosenfeld. Ms. Kaufman?
Thank you, Your Honor. May it please the court. A lawyer who commits the crime of obstruction of justice should expect to be disbarred.
That is the presumptive sentence.
And I would say the disbarment is especially warranted here because the lawyer committed his crime in his capacity as Speaker of the House in a voting rights case.
Ms. Kaufman, let me just ask you about the last point of Mr. Rosenfeld. As I read the board's decision and talked about the, quote, likely outrage, the first case, matter of ring, the lawyer's argument in that case, repeated contumacious violations of court orders. Here we don't have repeated contumacious violations. Bolero, there was, she made a false statement while she was testifying, and there was no disbarment. Matter of Hyatt, intimidation of witness and other misdemeanor offenses that interfered. It struck me that if the board or bar council is relying on that reason for disbarment, the cases on which, and the precedents on which the board relied don't exactly fit this case.
Those cases were cited for the proposition that any lie is taken very seriously by this court. They were not cited for the proposition that disbarment is always the result. Hyatt is different from the other cases that the court is looking at because Hyatt is the only conviction case. And in Hyatt, that was a purely personal matter. And yet the single justice held that so-called private citizen exception does not apply to any crime. So that's not in, this is not part of this case.
I was just looking to the cases to which the board, on which the board relied just for that piece.
Just, they were relying on those cases for the proposition that this is extremely serious.
Yeah, but it seems
Nobody knows that it's extremely serious.
Exactly.
It strikes me that your position depends upon whether a prosecutor, state or federal, has decided to prosecute somebody for giving false testimony. If they haven't decided to prosecute, then it falls into the Bolero category. If the prosecutor has decided to prosecute, it falls into the disbarment category. Is that fair? That the decision as to how this falls, the seriousness of how this falls, depends upon the determination of a prosecutor.
This court, in matter of Alter, found that a conviction carries special weight.
Of course it does.
Well, that is the answer then to the question.
Well,
yes,
except that Bolero was a 6-month suspension. And at the other extent, the other extreme, you have disbarment. And you're ignoring everything in between.
No, but Bolero was testifying in a personal matter involving herself as a victim. Mr. Finneran was testifying as Speaker of the House.
I mean, it was not truthful testimony nonetheless.
It certainly wasn't, and of course, in Bolero we were asking for a much harsher sanction than was given by this court. But just to compare those two cases and why this case is so much worse, is that Mr. Finneran was testifying as Speaker of the House in a voting rights case.
I understand, and as I read the opinion,
that's much more serious. That is a much more serious matter of much greater weight.
But isn't our responsibility to look at what he did as a lawyer? And he did nothing as a lawyer. He may have violated a public trust, and that would certainly weigh into it. But we've fairly carefully tried to weigh out the conduct of a lawyer or the misconduct of a lawyer in his capacity as a lawyer. We've done that in the stealing cases.
Not in obstruction of justice or cases involving the intentional interference with the administration of justice. Hyatt was not acting as a lawyer. He had not practiced as a lawyer for years, yet he was disbarred. He was disbarred for intimidation of a relative in connection with a private dispute over the administration of a will.
In asking us to depart downward, so to speak, Mr. Finneran's counsel has suggested that there are compelling circumstances here. So isn't that really a question with which we have to deal?
Yes, and I don't think there are compelling circumstances here. I'd like to just address them one at a time. The first is the alleged lack of evil motive. First, I want to say that Bar Counsel never alleged or argued that Mr. Finneran was motivated by racism.
In fact, there's nothing in the record to support that, is there?
No, there's nothing in the record to
And
support.
in fact, the three-judge panel, if one reads anything, talks about incumbency.
Exactly.
And the Assistant United States Attorney made a point of that.
That's correct. No one is saying that Mr. Finneran is a racist.
So you're saying that we should take more seriously the fact that it's a voting rights case as opposed to a domestic abuse case?
Well, yes, I think the voting rights case, I would say if Mr. Finneran had been convicted of testifying falsely or obstructing justice, or if Ms. Bolero had been convicted of obstructing justice, she should have been disbarred. The fact that she wasn't convicted made a large difference.
It wasn't that she wasn't convicted, she wasn't indicted.
Exactly. She wasn't charged at all. She was charged with no crime.
Well, then you get back to Justice Spina's question.
Well, yes, but the fact
Does the charging decision
that is
determine the outcome?
because when a lawyer is convicted of committing a crime, that does carry special weight. This court has held that time and time again. That's why the court does make distinctions between convictions. For example, matter of Consemi, Mr. Consemi was disbarred. Matter of Siegel did the same thing. He got a 2-year suspension because he hadn't been convicted. And you can see a number of the mortgage fraud cases that fall on either side of that equation. Those who were convicted got disbarred. Those who were not, and they are identified in the footnote in Consemi, got lesser sanctions because they had not been convicted. It is this court that's established that principle, and it's a correct principle because
Sorry, can I just ask you this? Because I'm looking at the board's basis for its decision.
Yes.
Right? And obviously that's important to us. And I was listening to you answer, perjury is perjury, obstruction of justice is obstruction of justice. These are serious, serious charges, and if there's a conviction that goes with them, that is serious. But I don't think that we have ever made a distinction between the nature of the proceeding. The board says, for example, that this isn't a, quote, simple civil action. I would tell you that people coming into courthouses, if it is a domestic violence case or if it is a termination of a tenancy case, that case is terribly important. Is there anything in our jurisprudence that says it makes a difference what the type of case is?
No, and in fact what the board was doing was it was characterizing the respondent's argument. The respondent is the one who says that a downward departure, if you will, is required here because he didn't lie in a criminal case or he didn't lie to cover up a crime. It was the board saying, this is a serious case. You can't trivialize this case. In fact, Mr. Finneran's own witness, Wayne Budd, said, I can't make the kind of calculation that the respondent's asking me to make. I can't say that a voting rights case is less serious than lying to cover up a crime. You can't make that calculation. And that's all that the board and Bar Council have been arguing. They are both very serious. And yes, if he had obstructed justice in any case, Mr. Hyatt's intimidation of a witness in a will dispute with his relatives, that conviction is serious, and that is going to result in disbarment unless there are substantial matters in mitigation. There are no substantial matters in mitigation here, and I want to just get back to
They're
the
all
motivation.
serious because lying before the court goes to the very heart of our justice system.
Exactly. We cannot have that. And there is no way to say you're not, to separate out the fact that he's a lawyer when he gets up and lies in court from the fact that he wasn't representing a client. That's why we don't apply that test in that arena, because you are attacking fundamental obligations that you have to uphold the law. And Mr. Finneran had them in two ways, as the Speaker of the House and as a lawyer. And his, as in the Clinton case...
So we should punish him for being Speaker of the House?
No, but he's not entitled to mitigation for that reason. That's what we're saying. This presumptive sanction is disbarment, and he is not entitled to mitigation because as Speaker of the House he got up and lied in court.
But we should treat him just like any other attorney.
Exactly.
He shouldn't be punished because he's Speaker of the House, and he shouldn't be given a lesser sanction because of it.
Exactly. He should get the sanction that Mr. Hyatt got. He should be disbarred. He is asking for credit because he was Speaker of the House and he had public service. I would point this court to the two decisions that it made in Curry and Crossan. Crossan had a distinguished public record. Curry, his character witnesses would fit into a telephone booth, according to his lawyer. They both got disbarred because what they did was very serious. And what this court held was that disbarment is the sanction for these types of crimes, or this, and in Curry and Crossan there was no crime, that go to the administration of justice, that affect the administration of justice.
But Crossan was acting as a lawyer.
Well, yes, but again, I'm simply making the distinction that a record of public service between those two individuals, Curry and Crossan. One had a distinguished record of public service. One had no record of public service, and yet the court did the same thing. That's why I'm comparing those two cases for that one point, Your Honor.
Yeah, and I'm raising them for the proposition that the severity of the offense was called for because they were engaged in the practice of law.
Yes, but going back to Hyatt, he was not engaged in the practice of law.
I understand that, but also in the Crossan case, it wasn't just a single abulation. Abulation is not my word, right? It was over many, many months, repeatedly against the advice of other lawyers, ignoring the advice of other lawyers.
This court has never held that you had to be convicted of a serious felony twice in order to be disbarred.
I understand that, but there are cases where we take into account what has been the prior history of a lawyer in practice.
Typically not where there has been a conviction of a serious felony offense involving the administration of justice. I am not aware of a case in this jurisdiction where this court has said, you've only been convicted of obstruction of justice or perjury or any serious felony once, and therefore, and typically with lawyers, it is aberrant conduct. That's typical. That you're going to get a lesser sanction.
I wouldn't say that based on the cases we've seen that that's typical.
That in conviction cases, typically there have not been prior convictions or...
No, because there's perjury in a particular case.
I'm sorry?
There's perjury in a particular case. Somebody hasn't been a witness in 100 cases.
Oh, yes, I understand that. But I'm saying typically when a lawyer is convicted of a felony, that they often have a record of a no record and have a good reputation in the community. So that it's not unusual to have that circumstance before the court. That's all I'm saying. So I'm not aware of a decision by this court where a serious felony conviction that involved the administration of justice was involved, where the court looked to see whether the lawyer had ever done anything like that before.
Are lawyers who are convicted of felony having to do with tax evasion, are they always disbarred?
No, tax evasion, they are not disbarred. Tax evasion typically results in a 1 to 2 year, occasionally disbarment, depending on the aggravated circumstances.
Are any of those convictions felonies?
Tax evasion is a felony.
But they're not disbarred?
That's correct, because tax evasion doesn't involve the administration of justice. And tax evasion, looking at the decisions by this court since 1974 typically result in a term suspension, although there are some that have resulted in more serious sanctions. I see that my time is almost over, so I want to say just this. I think the question of the public perception is very important here, and I think it is important
Let me just ask you, I don't mean to interrupt that argument, but what is the typical, the presumptive sanction for tax evasion?
I would have to say that typically tax evasion results in a 1 to 2 year suspension. Typically.
If you go to the board's decision on public perception, it said the testimony cited was character evidence, not expert testimony on the content and measurement of public opinion.
Yes.
And then it says, presumably adopting your argument, that public interest is a legal issue measured by the gravity of the misconduct. I didn't quite understand the board's reference to, quote, expert testimony on the content and measurement of public opinion. Was the board suggesting that when somebody raises a public perception that they should bring in, that they should do measurements of public opinion?
No, actually, it was the respondent who has essentially put forth that argument. He argues that public perception can be gauged by the fact that his character witnesses came in and testified to his good character. But that doesn't measure public perception, and that
No,
this
I
this
was just
court-
confused by the board.
Yeah, no, that was what the board was responding to that argument, and
You keep saying the board was responding to the argument, but it's not unusual for somebody to point to character witnesses as his reputation in the community. That's not unusual.
that's his reputation in the community, but that does not establish what is required from this court to address the gravity of the misconduct.
Stated differently, you're not asking us to say that if you raise a public perception argument that you have to go out and get expert testimony.
Exactly. You don't have
So
to
I
get...
didn't understand the board's references if this respondent should have done that.
No, but it's also not... it is also not an evidentiary issue in which bar counsel must go out and put witnesses on to testify as to what the public would perceive either.
Of course not.
Well, I think that's the concern here. And the argument that was made to the board was, well, bar counsel didn't rebut these witnesses. And that's not really the issue. It's really a legal issue. It's an issue really for this court to decide.
If I may, just one question as to this public perception. Are you saying that we should be governed by the extent to which we think public opinion will favor or disfavor our opinion?
No,
how does that play
no.
out?
The public perception issue is, what does this court deem to be required as a response to this crime to address the gravity of the crime, to encourage public confidence in bar discipline, and to be sure that there are even-handed results, that there is no disparate treatment here, to enhance the confidence that the bar is able to regulate itself. That's what public perception means.
Thank you, Ms. Kaufman.
Thank you.